You've recently filed a bankruptcy or are considering filing and are new to the process of what to expect. If that's the case, grab a snack, maybe a notepad, because you're in the right place. Let's get started. Welcome to Ascend Finance's YouTube channel, where we specialize in providing unbiased, complimentary bankruptcy calculators to help you understand how to get out of debt cheaper, easier, and faster. My name is Ben, and I'm the co-founder here at Ascend. Now, this video is for informational purposes only and isn't and shouldn't be construed as financial or legal advice. In this series, I'm going through my bankruptcy journey and what you can expect when you're filing if that's something you're considering. In this particular video, we will cover what you can expect when you are 21 to 50 days past your filing for what's called the 341 meeting. Other than this meeting, there wasn't much to do other than the debtor education course. As that was the most pertinent thing in my situation, we are going to cover what's a 341 meeting, sharing my 341 meeting experience, how to prepare for your 341 meeting. As a quick reminder, I'm doing this video series in the first person, but this is actually someone on our Ascend team that filed bankruptcy recently and wanted to share his experience with others to be helpful to other people. And with that being said, what is the 341 meeting of creditors? A 341 meeting of creditors is a mandatory meeting, also referred to as the creditors meetings. Its name comes from the section 341 of the Bankruptcy Code. The purpose of a 341 meeting is to examine the debtor's financial position and to confirm the facts stated by the debtor in the bankruptcy filing. Creditors are invited to attend, although it may be unlikely for them to show up. If a creditor does show up, they may ask questions about assets or income that you own or have access to. If you do not have answers for those questions or do not show up for the hearing, then the trustee could request that your bankruptcy case be dismissed. The purpose of the 341 meeting of creditors is for the United States bankruptcy trustee to review the documents that you submitted when you filed your case. Those documents are often referred to as your bankruptcy petition or bankruptcy schedules. In this meeting, the trustee puts the debtor, the person filing the bankruptcy, under oath and asks them a series of questions pertaining to their case. If you're curious what questions may be asked in this meeting, refer to the link below where I included some of those questions. Now, let's talk about my 341 meeting experience. In total, my meeting with the trustee was only about 4 minutes long over a Zoom call. I believe most of the 341 meeting of creditors across the United States are still on a Zoom call. We all met with the trustee and she told us that she would call us in one by one with our attorneys. She then removed everyone from the meeting room until it was our turn. When it was our turn, we got added back into the meeting. The trustee introduced herself and our attorney was in the meeting as well. The trustee asked us all to state our names for the record. After doing so, she had us raise our right hand and put us under oath. The trustee asked us questions about our bankruptcy documents and asked why we were filing bankruptcy. Ultimately, she was just trying to understand our situation. Now, a portion of my income was generated from a small business that was in the form of an LLC. When you're self-employed and are looking to file for bankruptcy, they ask you to fill out a form called a profit and loss, which I'll put a link on the screen so you can see what that looks like. The profit and loss allowed the trustee to get an example of what my operating expenses were and help get to my total gross income from the business. We discussed my business and how I generate revenue. The only hiccup throughout the whole meeting was the creditor asking for proof of Venmo statements for the past 6 months. In hindsight, it could have been much worse. Right after a meeting, we submitted these documents and there were no further issues. The only hiccup through our whole meeting was that the creditor asked for proof of Venmo statements for the past 6 months. Right after a meeting, we submitted those documents and there were no further questions or issues. Before we continue to our final point in today's video, if you're finding this information useful, please take a moment to hit that like button below the screen. Our goal here is to help people get out of debt cheaper, easier, and faster. And that is always encouraging to me to get the likes. And also it tells YouTube that this video may be helpful to others. Finally, we're going to cover how to prepare for your 341 meeting of creditors. First, you must attend the 341 meeting. This meeting is scheduled about 21 to 50 days after filing your Chapter 7 or Chapter 13 bankruptcy petition. If you and your spouse are filing jointly, you must both attend. Failure to attend can result in the court dismissing your bankruptcy case, which does not provide a fresh start or debt relief. What I would say, plan to arrive early. Whether you're meeting in virtual or in person, make sure to attend early. If the meeting is in person, if you hit traffic, get lost, or can't find parking, the trustee might reschedule the meeting for the next term or request dismissal. Also, you may be required to pass through security. If your case is in person, this may be something to plan for accordingly. Just like you make time for security at an airport, it may be important to make ample time for security here as well. Next, there may be multiple hearings that are scheduled every hour. Whether in person or virtual, there may be about 10 to 14 hearings every hour. Keep in mind that there are a lot of different cases they are juggling, so they are making sure everything is completed within a timely manner. Let's talk about how to prepare for the meeting of creditors. This is not a court hearing, so there is no judge present. Instead, the trustee assigned to your case conducts the hearing. To best prepare, you can review your bankruptcy petition, schedules, and statements you filed within the court. Make sure to be transparent about any errors you find. The trustee is unlikely to ask you anything you haven't already answered. Next, you must prove your identity. Make sure you have your social security card and driver's license or government ID present with you. Again, you are under oath. Make sure to tell the truth and do not guess. Most questions asked are what you have reported to the court in your bankruptcy forms. Again, creditors may appear and ask questions. Creditors have the right to appear and ask you questions about the debt. For example, they might ask whether you still have collateral that secures a debt or other valid questions. However, you will not be harassed at the meeting. They are not allowed to be abusive or threatening. In most cases, creditors do not appear at the meeting. However, by them not attending the meeting does not mean impact a creditor's right in the bankruptcy case. Next, you must supply required documentation. Some trustees may require current pay stubs, bank account statements, property tax bills, life insurance statements, and other proof of assets values 7 to 10 days before the hearing. Many trustees have notices on their website that list documents debtors must provide to the trustee. If you are unsure, call the trustee's office. The number is on the bankruptcy notice to ask them if the trustee requires any documents before or at the meeting. Another thing to consider is that you might not know anything about the status of your case. They may not always share the status of the case unless for a Chapter 7 bankruptcy. Generally, the Chapter 7 trustee announces whether it is a no asset Chapter 7 case or an asset Chapter 7 case. So, summing it all up, all in all, parts of the bankruptcy process such as this can be very intimidating. Ultimately, being transparent, prepared, and fully honest can set you up for success in all stages of the bankruptcy filing process. As I mentioned before, bankruptcy is not the only option we cover here at Ascend. If you're hoping to chat with me or someone on my team about bankruptcy and other options, please call or text the number at 833-272-3631, and we'd love to have a complimentary call with you. Discussing your situation with our caring and knowledgeable team member does not cost anything to you. Our priority is to help you find the most affordable, quickest way to resolve your debt problems based on what's best for you. Thanks so much for watching and hope you have a great day.